Welcome to Legal Consolidated. My name's Professor Brett Davies, and I'm going to teach you and educate you about contractual will agreements. So firstly, the biggest concern people have is a contractual will agreement a will? No, it's not. It's a contract not to change your will. It's an inter vivos, so it's why you do it while you're living. You do a contract to say, I will not change my will, and the other party, often your spouse or your second wife, will also agree in the same agreement not to change her will after one of you dies. Now, with all our documents, you can see a full free sample of the document before you begin, and also there's a checklist. Before we press the big green button to start our free education, so you can start building for free and start educating ourselves, let's just have a look at some of the introductory information. So here's an example of a contractual will agreement, and it's between two single wills. That's interesting. I thought it was going to be just all to mum, all to dad. No, it can be between two single wills. So if you have a look here, so this is one will, and in this will, let's say it's dad's will, and he leaves everything to his children, 100% everything to his children. Second marriage, he leaves everything to his children. His second wife also leaves everything to her children. So they don't need to be everything to each other type of agreement. And that's two single wills. The other type of a contractual will agreement is where you've got mirror wills. Now, what's a mirror will? So let's have a look at an example of a mirror will. So here's an example of a mirror will. Another training video there. What happens here is that dad is leaving everything to mum, and mum's leaving everything to dad in the first instance. So it's the very nature of a mirror will. Everything gets left to each other, and then everything gets left to the same group of people. So it might be, as contractual wills are often between second spouses, that with children of different relationships. I might, as the dad, I'll leave everything to my wife, my second wife, and she leaves everything to me. Once we're both dead, half goes to her children and half goes to my children, whatever's left. So in this example, there are two single wills leaving nothing to the spouse. That's the example we gave to begin with, where mum has left everything to her children, nothing to the husband, and you've agreed to that, making it very difficult for you to now challenge the will of your wife or your second wife was to die first. Example of two single wills leaving a bit to the second spouse. So here we go. Mike leaves 25% to his new wife Carol, and the rest goes to his children. Carol leaves a third to Mike and a third to her favourite charity, and the rest to her two children. That's what she does in her will. That's what he does in his will. Two separate wills. But you sign an agreement called contractual will agreement, so you will not challenge that will when and if your spouse dies. Well, you make the decision to do a contractual agreement and you do die, and now your surviving spouse wants to change her will because one of your children was mean to her, which you can't. It's a contract. And your children can now sue her if she's wasting assets. A lot of people in their second marriages have accumulated a lot of wealth, and it's still important, even though you be independently wealthy, that you don't want problems for your children, for your spouse's children. So a contractual agreement will get rid of those problems. So what's the process? We're going to see the process in a minute, but firstly you build your wills, either mirror wills, everything to each other, or two separate wills, which are not everything to each other. You sign those wills and you take a copy of the unsigned wills and you staple them or bind them with the contractual will agreement, which we're going to be building in a few minutes. You'll be seeing also lots of hints. You can see that our law firm is highly educational and that you will be educated in the ways of contractual will agreements. Now, one of the questions that a lot of my students face is that a will can always be challenged. That's true. A will can always be challenged. So I'm going to put a clause in my will to say that if my second wife challenges the will, she loses everything, or whatever it was. Let's say we left her $500,000 in my will, and if she challenges it, she loses it. That restriction is void it's void for public policy. You can't put things in your will to stop someone from challenging your will. If a person's got a right to challenge the will, then they can do so. I'm your son, and you've left me 99% of everything you own. I could still challenge for that 1%. Now, sure, I'm not going to win, but I could still challenge for that final 1%. You can put a considered person clause in your will. That makes it expensive and hard to change the will, but they can still challenge the will. So how is a contractual will different to putting a clause in the will to say it cannot be challenged? And that's the rub. That's the importance of the contractual agreement, and that's why it's enforceable in Australian courts. In a contractual will agreement, you're entering into a contract. You make a promise, your spouse makes a promise, and you rely on that promise, the very nature of a contract. I agree not to change my will after you die, and you agree not to change your will if I die first. It's a contract, where something in a will is not a contract, it's just a will. Well, are they legally valid? Well, let's have a look at this is High Court authority, so the highest court in Australia is the High Court of Australia. And it says here in Birmingham and Renfrew, a contract between persons to make corresponding wills gives rise to equitable obligations when one acts in the good faith of such an agreement and dies leaving the will unrevoked, so the other person cannot change it. The survivor becomes a constructive trustee, and the terms of the trust are those of the will which he undertook would be in the last will and not change it. So the High Court has enforced contractual will agreements. Well, that all sounds really good, but they're not for everyone because they have restrictions. Now, if you're used to travelling business class and your husband's just died and he's got, let's say, 20 million, well, you can only continue to fly business class. You can't start flying first class now. That's kind of restrictive because you might want to fly business class, or worse still, you only used to fly economy class and there's 20 million in the estate. Well, you can only sort of continue the same lifestyle you had before your partner died. So there are restrictions there, and if you break those and start wasting assets, you can get sued. So this is not all beer and skittles here. There's a lot of obligations. Comes with consequences. But how much flexibility is there to manage the assets when I die? Well, you can use the assets as your normal lifestyle. You can even sell a property, like the family home, and move into a nursing home. You can downsize. The surviving partner is restricted from giving assets away or squandering them or wasting, as I called it. If you breach that rule, then you will be sued, probably by your dead spouse's children, to enforce it. Well, what are the rights? Well, you can start a lawsuit, you can get performance, you can injunct, so you can stop assets being sold. Is a contractual will a will in itself? No, I've just said that. It's an agreement not to change the two wills. It's not a contract that relates to it's a contract that relates to a will. It's not a will in itself. When does a will become operative? So when does a will start? It starts the moment of death. It has no validity or of any interest until you're actually dead. When does a contractual will agreement start? The moment you sign it. It's inter vivos document. It starts on the moment you sign it. Starts today. You're still living. Your spouse is still living. The contractual agreement has started. It's in play. And yet from that point on you cannot change the will, except we'll see some exceptions to that. You can change your contractual agreement at any time, provided the other person has time and mental capacity to change their own will. Well, I got married a second time, as 2/3 of all second marriages don't work. We've just broken up, and I'm just letting you know, ex-second spouse, that I'm no longer going to be agreed to be bound by the contractual will agreement. I've torn it up. You now have time to remake your will. So the second spouse now has time to remake her will, leaving everything to her children or whatever she decides to do. The deal's off. But if I've got dementia and I can no longer change my will, my second spouse, it's finished. She cannot renounce the contractual will agreement. It's no longer possible. So here are some examples. My partner is in a coma. Can I cancel the will? No, of course not. You can't revoke your contractual agreement if one of the parties is of unsound mind, because they can't redo the will. Now, obviously, this is how Legal Consolidated drafts the contractual agreement. Every tax and superannuation lawyer will do it differently. This is how we draft it. This is the document you're building. If you're building a contractual agreement with another law firm, then you need to speak with them as to how they draft it. My partner's lost mental capacity. Can I cancel the contractual will agreement? Of course you can't, because the person that's lost mental capacity cannot make a will. You have to have mental capacity to make a will. My partner is dead. Can I cancel the contractual will agreement? Well, of course not, because a dead person cannot remake a will. In fact, the whole reason for the contractual agreement is to ensure your will's not changed. We want unsigned copies of the will. So why are we attaching unsigned copies of the will? Because if you've got a signed copy of the will and you fiddle with it, like you put a piano to John or dressing table to Joanne and little things like that, it could become the new will. So that's why lawyers are often reluctant to want you to photocopy signed wills, in case you start scribbling on it, can become a new will. Condoned spouses, so these are non-married couples and non-de facto couples. Can they make a contractual will agreement? Yes, anyone can make a contractual will agreement. You don't need to be a couple. And here's one example which we gave advice on recently, which is two aunties. They leave everything to each other, and then they've left 25% to their nephews and nieces and 75% to the local church. Same-sex couple with no children, it's the same thing. Whether you're same-sex or heterosexual, it's still all something else. It's the same thing. You can still do a contractual will agreement. Now, this is problematic. Mutual wills. Professor Davies, I've heard that when you do mutual wills, Legal Consolidated does not prepare mutual wills. We do we do mirror wills. But I've heard, Professor Davies, that mutual wills in themselves are contracts not to change the will. I leave everything to my spouse, she leaves everything to me. That can now not be changed. You could be correct. There have been court cases which said that mutual wills are contractual of nature. But there's also cases that say that's not the case. So you are in dangerous ground, very dangerous ground, if you rely on a mutual will in order to enforce a contractual agreement. And it's not something our law firm would be involved in. We don't like that situation. And have a look at Hussey's case. It shows that mutual wills can be changed after the first person dies. So in this case, one of the parties died. They had mutual wills, and the court said it was fine for them to change the will. An example where a mutual will was not of contractual nature. So don't rely on mutual wills. Don't look. If you're interested in mutual wills, come and do my estate planning course at my university, and we can certainly spend a bit of time. You can write your PhD thesis on it, but it's not for you. Just do things which don't cause trouble. Keep your head down, act demure, do a contractual will agreement. Do I have to leave everything to my spouse to make a valid will contract? No, you don't. You could, as we said before, two single wills can leave everything to your own children and to your husband's, your second husband's two children. I mentioned that void for public policy, and that I had in my will that I will leave $100,000 to this person if he remains or marries a Catholic girl. Void. He still gets $100,000 even if he marries a Baptist. I will leave $1 million to the church if they don't support gay people. They still get the $1 million whether they support gay people or not. So there are certain things you cannot put in the will. They're void for public policy because society deems it to be inappropriate. And the example we gave earlier is that I leave everything to my my second wife, $1 million, if she doesn't challenge the will. She can still challenge the will. You need a contractual will agreement if you don't want that to happen. We're an Australian law firm, and we don't give advice for matters outside of Australia. But most countries, from what we see from our research, also recognise contractual agreements. But don't rely on that. If you've got assets in California, you've got a spouse in California, you better check with your Californian lawyer. And if you need one, just email the law firm. We can recommend lawyers that specialise in that area around the world. Life estates are where I don't give you the asset, but I give you the right to live in the asset to the date of your death. So we own a $5 million property in Double Bay overlooking the Sydney Harbour, and I am going to give my second spouse a right to live in that property the day she dies, and she'll do the same for me. That can also be locked into the contractual will agreement, so it can't be challenged. We've already looked at, can mutual wills or mirror wills themselves be contractually binding? I don't know. Some cases say they can, some cases say that they can't be. If another law firm prepared your will, then the contractual will agreement still works. So if you've got wills prepared by other law firms, this contractual agreement will still operate. Mum is dead. Dad remarries, now what? So you can do, I've been talking about second relationships, but you can actually do a contractual agreement between a mum and a dad. They're not normally that common because when you get married and have children only from that relationship, you only have one master, and that is to protect your spouse and your child. I was a pacifist until I had my child, and now I'm a father. I'd kill to protect my son. I would do anything to protect my son. And that animal instinct inside you tends to be not a requirement to have a contractual will. Whereas if I remarried and my spouse has different children, well, my loyalty's not to her children. I will love her children, but they're not. My loyalty is to my son. That's why contractual will agreements are very common between second spouses. Look, I won't kill people if they're mean to my child. It's just trying to get my point across. Well, that's the information. Now I'm going to start building the will. So our free building process is highly educational. You just need to put your username in and password, or join up if you haven't done so. I could pick up data from another document that I've drafted. So some accountants, lawyers and financial advisors may have done hundreds of documents, and they can just pick up data from an old document that they did for you. I'm going to press Contractual Will Agreement. I'm starting to build. Now the first thing I note here is I've got lots of hints, and yet another training video. What is a Contractual Will Agreement? Does a court honour these agreements? So there's lots of free hints there, and that's why don't ring us up. Start the free building process first. Get blooded in the ways of a contractual agreement. After you've had a go and answered many questions you can, telephone us and we'll give you help on building of this document. But start the process first. I know your circumstances are extremely strange and unusual, but these documents we've been doing since 1988, and any questions have been asked, we've put them into the hints. So the first name, middle name, date of birth, you are best to put in residential addresses. No one likes post office boxes, so put in a residential address. If your address changes, there's an email. There is a advice on that. So I've got the, bit unusual for a first name. I've got the partner, spouse. That doesn't have to be a spouse, but just another person that you want to lock in so they don't change their will. Reference, contractual will, I'll just mark that Smith. Go to next. Now, something very important's happened here. Our law firm is responsible for this document. We control the logic flow. We control every aspect of this document because it's got to be correct. So you'll see that the green ticks are there. That means we are comfortable with the logic flow that you followed. And this is quite a basic document, very easy to draft document. We just need your names and addresses. But the summary allows you to check the data, and I'm satisfied with it. Now I'm going to press lock and build. I'm going to put in my details of my credit card. And success. The document has been built, takes about 60 seconds, and it will be emailed to your email you've used on your account. It's also available in 10 years' time or whenever to go back in, to log into your account to see the document, and you can also access the document immediately, which we'll do now. So there it is, contractual agreement. There's the invoice, the contractual agreement. Now it's downloaded as a PDF. Why? Why is it a PDF? Well, we do not want you to change this document. It's a legally binding contract prepared by an Australian law firm. We don't want you fiddling with the document. If something needs to be changed, email us and we'll prepare a voucher for you so you can update it for free. But do not change these legal documents. Now, many of the people that build legal documents on our website are lawyers themselves, but lawyers are not going to change this document because we remain responsible for it. So do not fiddle with this document. Law firm's letterhead, how to print the document, reading glasses, so lots of good advice there. So this cover letter signed by the law firm, and there's the contractual will agreement. So in consideration of husband 2 taking the obligation of this deed, the spouse has signed a will, an unsigned will, a copy is attached, and then the spouse has done the same thing, an unsigned copy is attached. And there's the agreement not to diminish the assets during your lifetime. Assets after death are not part of the deal. So any assets you die, any assets your spouse gets, you might get something from her mum and dad, or from a dead mum and dad, or from a working, that her assets to deal with that she sees fit. Now it's signed as a deed. Well, what does that mean? In Australia, it is important to sign documents by way of deed. Therefore, they don't require consideration and they are more likely to be enforced in the courts. So a deed is a very important part of this document. 2 witnesses, that's interesting. So apart from wills and powers of attorneys, most Australian documents do not need 2 witnesses, but we put 2 in here because we want to be in a position so that when the person's dead, they're dead, and they can't say what happened back 30 years ago when they signed the contractual will agreement. Therefore, 2 witnesses help with that. And there's the other spouse. You will need to have a doctor's certificate to say you're of sound mind. Oh, Professor Davis, I'm 35 years of age. I run a multi-million-dollar company. I'm not going to get a doctor's certificate to say I'm of sound mind. It's ridiculous. Yes, it's probably not needed. But in 38 years' time, when you do die and you're 68 years of age or 70-odd years of age, no one knew what happened back in those good old days before artificial intelligence and all those things. The good old days, as the old people call it. You do not want to take risks. You're paying this law firm a lot of money to prepare this contractual agreement. You want to make sure it's as legally binding as it possibly can be. You get a doctor's certificate. There it is. Congratulations. You have now been able to build a contractual agreement. Start building the document for free. Read all the free hints. If you need help drafting the document, telephone us, but start the building process first. Enjoy the free education.